Hi everyone, thanks so much for joining us. I am Julie Kruger and I'm the owner of Kruger Immigration Law. We're a small boutique immigration law firm based in Buffalo, New York, and we have a by appointment only office in Toronto, Ontario. Our firm is limited, our practice is limited solely to immigration law, and we handle all types of immigration cases, including family-based cases, business-based immigration cases, citizenship and naturalization cases, removal work, waivers of inadmissibility, and other admissibility issues. If you have an immigration case that you'd like to speak with me about, I'd be happy to speak with you. I've been an attorney for about 9 years, and my practice has always been focused specifically on immigration law. And you can find me on the web at www.krugerimmigrationlaw.com. You can reach me by phone at 716-393-9878, and my email is julie@krugerimmigrationlaw.com. We offer a free case evaluation, so if you have a job offer in the United States, or a U.S. citizen or permanent resident, parent, spouse, child, brother, or sister, someone who can sponsor you for an immigrant visa, I'd be happy to talk with you about your case. If you're in a removal proceeding or applying for citizenship, or looking to apply for a passport, those are all the kind of cases that we handle, and I'd be happy to do free case evaluation with you. So thanks so much for joining us today. And today we're going to talk a little bit about some current immigration processes, changes that we're seeing, a few updates, and some of the challenges that we're seeing in our practice. And so I'm going to start with talking about some of the process changes we're seeing at the Canadian border. We're right here in Buffalo, New York on the Canadian border, and we do a lot of border processing cases, and we're seeing some changes in the way that cases are processing at the border, especially in business cases. So one of the cases that you historically have been able to apply for at the border as a Canadian citizen is an L visa. An L visa is a business-based visa for an intra-company transferee, where there's a company outside the U.S. where someone has worked for more than a year, and the company is transferring them to their U.S. maybe affiliate or branch or subsidiary. Historically, you've been able to file that application right at the border, same-day processing, pay the filing fee, and get a decision right then and there. That has changed over the last couple of months. So we have seen U.S. Customs and Border Protection is no longer accepting L visa applications at the border unless you are what's called an intermittent L visa. So where you're not actually based in the U.S., you're just coming into the U.S. every once in a while to work for the U.S. branch or subsidiary of your company. But most of the time you're residing in Canada outside the United States. More than 50% of the time you're spending outside the United States. So currently the border will continue to process those intermittent L visa applications, but this has been kind of a dramatic change over the last couple of months. Customs and Border Protection has, sometimes on a daily basis changed, or port by port basis, changed what we're hearing as immigration attorneys, the kinds of L visa applications that they will accept and the kinds that they won't. So some ports for a little while were taking new L visa applications, but not renewals. Then they stopped taking new applications. So right now, as we understand it, the border will only take those intermittent L visas. That means that instead, Canadians are no longer able to go to the border and get that same day processing, and are processing as citizens of other countries do, where you're filing your application or your petition with U.S. Citizenship and Immigration Services, paying for premium processing if you want to have that processed a little quicker, and getting a decision from U.S. Citizenship and Immigration Services, and then coming to the U.S. Once your petition is approved and coming to the border with that approval. So that's really kind of a dramatic change from the processing of L visas previously. That's something that's just happened over the last couple of months. Something that was just announced this week that's changing at the border, the Canadian border, is the processing of waivers of inadmissibility. So this is for Canadian citizens, and again, historically, Canadian citizens have been able to prepare their waiver of inadmissibility application and bring it right to the border, file it at the border. A waiver of inadmissibility is where someone is barred from coming into the United States for whatever reason, perhaps a previous criminal conviction or an immigration violation. And they're showing that they are no longer a risk to U.S. society, and that they have been rehabilitated, and why they want to come into the U.S. That application goes to the Admissibility Review Office, and the waiver can be approved for up to 5 years. Again, historically, Canadians could file that right at the border. This week, U.S. Customs and Border Protection announced that they are moving to an electronic filing for Canadian citizens of those applications. They're going to start to roll out this program they're calling eSafe, and where you will file your forms online. You'll be able to upload your documentation online, and you're supposed to be able to follow and track the progress of the application online. So that'll be a new change. As far as I'm aware, that hasn't fully been rolled out yet, but that's something that's just been announced. A waiver of inadmissibility is something that you're definitely going to want to have a competent and experienced immigration attorney assisting you in the preparation with and the processing of. And so, as I understand it, again, that eSafe new electronic processing will have a special attorney portal profile as well, where your attorney can upload the forms, submit the documentation, and follow the case along for you. So that's something that's new. The other thing that we're starting to slowly hear, and this hasn't been announced yet, but I've heard this from a few other attorneys, that perhaps that some people applying for TN visas at the border have been told that TN visas will no longer be processed at the border. Customs and Border Protection has not announced that yet, but that seems in keeping with some of the other processing that we've been seeing with, for example, those L visas and the waivers. So I would not be surprised if sometime in the near future, CBP announces that they will no longer process TN visa applications at the border, and instead those will have to go through U.S. Customs and Citizenship and Immigration Services, and perhaps or applying for a visa at the consulate. So that's something that hasn't been announced, but the trend seems to be heading that way. So those are some updates that we're seeing in border processing for Canadian citizens. Some of the other updates that we're seeing, changes that we're seeing in immigration processing, include in immigrant visa applications. So our practice, we do a lot of family-based applications where we've got a U.S. citizen or permanent resident sponsoring a parent, spouse, or child, or brother or sister to come to the United States and become a permanent resident, someone who has the right to live and work here permanently. If you are outside the U.S., that's a two-step process. First, the U.S. citizen or permanent resident files a petition for alien relative. Once that's approved, the foreign national files an immigrant visa application. We've been seeing much slower processing of those initial petitions for alien relative. In the past, I would say we were seeing processing times of maybe 6 months that's the Form I-130, the petition for alien relative. And recently, that processing has really slowed dramatically. So quicker processing can be 7 to 9 months and can go even longer from there. The processing of those petitions is also supposed to be moving towards an electronic processing, which is designed to be a quicker processing. That transition hasn't been fully made yet. And the 1 or 2 cases that we have that are processing electronically have actually processed slower in the transition from USCIS to the immigrant visa process. So far, we're seeing really minimal cases being processed electronically, and that it hasn't necessarily sped up the processing of the case in total, but that is the intended effect of moving to the electronic processing. The other immigrant visa challenge that we have seen in our practice is with citizens of countries who are subject to the president's travel ban. So citizens, particularly, we handle a lot of cases of citizens from Yemen, and whose cases are processing perhaps through Djibouti or Egypt or Malaysia, and are subject to the travel ban. The approval rate of the travel ban is very low. And the actual, the processing is extremely slow, and even if the case is approved, whether or not the visa actually gets issued is an open question and takes a long time. So The statistics, there are very few, there's really very few hard statistics available for that, but the limited information that we have is that of citizens of countries who are subject to the travel ban, that approximately 6% of those cases have actually been approved for visas, and of that 6%, certainly some portion of those applicants were determined not to be subject to the travel ban for whatever reason. So those people who have actually been approved for waivers of the travel ban is actually less than 6% of the applications, could be as low as 1 or 2%, we don't know. And then even of the cases that have been approved for the visa or the waiver plus the visa, many of those approved visas have not actually, the visa isn't then actually issued, and the applicant isn't even able to come to the United States even though their visa has technically been approved. So we've seen really dramatically slow processing times of those and very, very low approval rates. The other difficulty with the travel ban is each consulate or embassy is handling the processing of those slightly different. And there isn't a standard process. There isn't a form to apply. There isn't a list of required documents. There isn't always a good way to submit documents, or if there is, to get the consular officer to accept the documents that you want to submit at the embassy or consulate during the person's interview abroad. So those cases have really significant challenges to getting approved. So that's something that has really been a challenge in our practice. Some of the other issues, current issues that we've seen in the processing of naturalization applications, we have actually seen a little bit faster processing, which is exciting. We have a bunch of cases that have sat for quite a long time with very slow processing. It seems like, at least here in the local office of the Buffalo USCIS, the processing has started to go a little bit faster, and we're seeing some of those old cases being called in for interviews, which is great to see those moving forward. However, at the same time, and this is kind of across the board with immigration, we're seeing very strict adherence to the criteria for approval. So when those old cases are being called in, the officers are really looking for all of the information necessary to prove that the applicant meets the physical presence and continuous residence requirements, meets the good moral character requirements. So it's important, if your case has been sitting for a while and you've been called in for an interview, not just to assume that the officer already has the information they need from when you previously filed, but really to review what's happened since you filed the application, and to review the kind of documentation that you submitted, speak to an experienced immigration attorney so that you can go into your interview and provide an updated package with your updated address and work history, your time outside the country, anything new that's happened that would affect the application, and then also an updated package to show that you're a person of good moral character and qualify for naturalization. So that's something that we're seeing as well. So that's it for today. Just a couple of quick updates, challenges that we're seeing in our practice. Again, I'm Julie Kruger of Kruger Immigration Law. I thank you so much for joining us. If you do have a case that you would like to speak with me about, please give us a call. We do a free case evaluation. You can reach me at 716-393-9878. Find me on the web at KrugerImmigrationLaw.com or email me at julie@KrugerImmigrationLaw.com. Thanks so much.